What's up, everybody? Welcome back in to another episode of The Lawyer You Know. We've got the mic fixed and we're ready to rock and roll here as we have the Supreme Judicial Court's decision on Karen Read's motion for them to, it was actually them affirming Judge Cannoni's denial of Karen Read's motion to dismiss, but for all intents and purposes, they've denied her request at a dismissal on counts 1 and 3. The second trial is moving forward on all 3 counts. Hank Brennan and the prosecution team for the Commonwealth will be able to argue her guilt under all 3 counts. Obviously, that adds in a lot more potential jail time. And while the decision of the Supreme Court is not surprising at all, some of the reasoning and their discussion, I think, is a little bit surprising. I think it will surprise some people who listen to it as we read through it. And we can learn so much from reading through this opinion together. So we're going to take some time. We're going to go through it, and we're going to start right now. So it may be hard to read on the screen, but as always, don't worry about it. I'm going to read every word we talk about together. It's 35 pages. We're not going to read all 35 pages. We are going to skip some of the procedural history that we've already broken down ad nauseum about what happened in the trial, the verdict, the jury notes, the jury affidavits, the arguments by the defense, the arguments by the Commonwealth, because our focus is really going to be on what does this court see? Why do they come to the determination that they will not dismiss counts 1 and 3? So the first paragraph of the entire decision sets out what the defense is trying to do. The defendant challenges the denial of her motion to dismiss after her first trial ended in a mistrial. That trial was lengthy, spanning 8 weeks of evidence involving 74 witnesses and 657 exhibits. The defendant does not contend that this evidence was legally insufficient to support a conviction on any of the charges, which would preclude a retrial. Instead, her argument focuses on whether the trial judge properly declared a mistrial and the relevance, if any, of post-trial accounts of jury deliberations. So that is the question we're all trying to get the answer to from this Supreme Judicial Court. And it's important to know what the question is, right? Because what are they answering? Are they saying Karen Read is guilty? No. Are they saying the jurors would have convicted her on count 2 or of a lesser included? No. We have to focus in on exactly the question that this court is answering. And those are the questions. Was the mistrial appropriate? And is there any relevance to the juror post-trial comments that came out? And that's what we're going to get into the discussion here today. But a couple points throughout this document, they discuss what the defense does not contend. The first one here is that the defense does not contend the evidence was legally insufficient to support a conviction on any charges. That does not mean the defense is saying that they agree there's enough evidence here to convict Karen Read. Obviously, that's not what they're saying. But in many cases, especially when we read appeals after conviction, they'll make the argument that there just was not enough evidence here to convict anybody. No reasonable juror could ever find the defendant guilty of these charges. So when that's the case, and we have the information that they didn't argue it, it almost sounds like the court wishes they would have, and they would have taken that under consideration. And I've seen people saying that, oh, the defense dropped the ball. Not really, because there was at least evidence presented that if the jury agreed with that evidence, then they could convict Karen Read. Obviously, the defense doesn't think any of that evidence is legitimate. It doesn't have any credibility. And their third-party culprit defense and their arguments that there's just not enough evidence or the investigation was so poor is still what they're going to argue. And this doesn't change that, number one. Number two, they would not have won with that argument. I will just tell you. They would not have won without that argument. Okay. We're going to skip, like I said, them describing what happened during the trial, what the arguments were that was made by each side. And we're going to jump to their discussion here. Okay. Propriety of declaring a mistrial. The double jeopardy clause of the Fifth Amendment of the United States Constitution generally precludes the Commonwealth from trying a defendant more than once for the same offense. Federal double jeopardy clause applicable to states by the 14th Amendment. However, an exception to this general rule applies when a mistrial is declared due to manifest necessity. In such instances, the double jeopardy clause does not bar the state from retrying the defendant. To determine whether the declaration of a mistrial is manifestly necessary, A trial judge balances the defendant's valued right to have his or her trial completed by a particular tribunal against the interest of the public in fair trials designed to end just judgments. A hung jury has long been recognized as a traditional example of manifest necessity, allowing retrial without offending the defendant's double jeopardy rights. Absolutely no argument there. So much of what the Supreme Judicial Court is going to say in this order is exactly what you expect, is exactly what all the precedent is. And that is some of what may confuse some people or surprise some people, I should say. It may be surprising to some people to hear that this is the status of the law in America. And when we discuss it, this is what they almost have to do. They don't really have a choice when all the case law points in one direction. All the case law says you have to decide it this way. Well, when that happens, their hands are almost tied, right? And they don't want to upset the apple cart by making a decision that is going to be contrary to all the precedent, unless it's obvious and there's some interest of justice that is necessary, which a lot of people feel is there in this case. But in this argument, it's not really there, which also leads me to pretty much the most important point of all of this, and that is, do not underestimate the power of law enforcement and prosecutors. The Commonwealth, the state attorney's office, the DA, do not underestimate the power they have, and law enforcement, when they investigate, when they charge people. It is so hard to win or to get over it. Even when you have something like this where you convince some or all of the jury on some counts you're not guilty, guess what? They get to go again. They have all the power. They make the decision. So when we discuss what should have happened in this case, in that 1 and 3, we said, if I was the prosecutor, I'd drop 1 and 3, just go forward on 2. But that's purely prosecutorial discretion. That is not a situation where the Supreme Judicial Court is just going to step in and make that decision for prosecutors, because that would create a situation where, should they do that more often? I'm talking way too much for 25 pages of reading I have to do. The decision to declare a mistrial is entrusted to the sound discretion of the trial judge. So you're starting to get where they're going. Trial judges receive such discretion to avoid the possibility of coercion measures being used to force jury agreement, thereby protecting the failures of the proceedings. I also think it will help us understand the fairness of this decision by the Supreme Judicial Court by starting to think about it in a little bit of a different context. Let's take out the Karen Reed story and let's assume a defendant is appealing a guilty verdict after the court continued to push the jury, would not let them go, even though they said they're not going to come to an agreement, and they end up coming back with a guilty verdict. If that were to happen, then I think we would look at this very differently, but I think the Supreme Court would make the same decision or the same analysis that you cannot coerce jurors and push them too hard after they've already said they're hung. In evaluating whether a trial judge abused his or her discretion in declaring a mistrial, a reviewing court considers whether the judge carefully explored alternatives to a mistrial and whether counsel were given full opportunity to be heard. And we know what the defense's arguments are on that. If these principles were followed, there is no claim for insufficient evidence to support a conviction. Double jeopardy will not prevent the defendant's retrial. Here, we discern no abuse of discretion in the trial judge's decision that the jury were at an impasse and that a mistrial was manifestly necessary. After extensive multi-day deliberations, the jury submitted several increasingly emphatic notes about their inability to reach a unanimous verdict. By the time the jury sent their first note, they had deliberated for approximately 19 hours over 4 days. That note stated that they had conducted an exhaustive review of the evidence and given diligent consideration of all disputed evidence. Following the judge's instructions to continue their deliberations, the jury deliberated for another 5 or 6 hours, spanning a Friday afternoon and the following Monday morning, before sending a second note that was noticeably more definitive. That note stated that the jurors were deeply divided by fundamental differences and that consensus was unattainable. And that is an interesting point. So they did quote the jury notes. Consensus being unattainable, you can read that in a way that says consensus is unattainable, period. Consensus is unattainable on any of the counts, which I understand that. I see a lot of people in the chat saying Mark Betterow has joined Karen Reed's defense team. Isn't that interesting? We'll have to talk more about that later. Echoing the language from other cases where we have characterized a jury's report of a deadlock unambiguous. The second note further emphasized that the deadlock arose not from a lack of understanding or effort, but from deeply held convictions that each of the jurors carried. By this point, the jury had already deliberated approximately 24 hours. The defense counsel described them as hopelessly deadlocked, but the trial judge did not immediately conclude that all hope of attaining a verdict was lost. Instead, she issued the Tui Rodriguez charge, a standard instruction that encourages deadlocked jurors to reach a verdict by giving more serious consideration to opposing points of view. After nearly 4 hours of additional deliberation, bringing the total to approximately 28 hours, the jury submitted a third note that was even more emphatic. It stated that further deliberation would be futile, only to serve to force us to compromise our deeply held beliefs. While there is no mechanical formula for determining whether a jury is genuinely deadlocked, quoting Illinois v. Somerville, the trial judge acted well within her discretion in concluding the jury were at an impasse and a mistrial was manifestly necessary. And even the defense, if I'm being honest, agreed to that at the time. We all kind of know that and saw that coming with how the defense was acting. Hindsight is 2020 though, right? The defendant contends that despite the jury's deadlock, the trial judge failed to adequately consider alternatives to declaring a mistrial. Yet, as discussed, the trial judge did consider and pursue such alternatives. After the first note reporting deadlock, the judge instructed jurors to continue their deliberations. After the second note, the judge issued a Tui Rodriguez charge. It was only when the jury submitted their third report of deadlock, at which point the judge was statutorily precluded from ordering them to continue deliberations without their consent, that the judge declared a mistrial. Nonetheless, the defendant argues that the judge should have inquired whether the jury had reached an agreement on any of the charges. Had the judge done so, the defense asserts she would have discovered that the jury had agreed on counts 1 and 3, allowing for a partial verdict. We disagree. So there it is. This court disagrees with the defense's argument that if they would have pushed, there would have been a verdict on counts 1 and 3. And that's the really important part of this analysis. What would have happened? How do we know? Should they have done things differently? And at the time, none of us were calling for this. Nobody covering this case, the defense attorneys themselves, the Commonwealth, nobody was calling for the judge to push to find out if we had reached a verdict on 1 and 3 because we just didn't know based on the jury's notes. Now, when we found out the evidence afterwards, I'm a big fan of justice. I want to push for justice. In the interest of justice, I wish she would have questioned the jurors. I wish the Commonwealth would have dropped the charges if we would have gotten information that they were unanimous, not guilty on counts 1 and 3. But we never got to that step. And because we didn't get to that step, there's not really a ton the Supreme Judicial Court can do. Rule 27B of Massachusetts Rules of Criminal Procedure gives trial judge discretion to require a jury to return a verdict for charges on which they have unanimously agreed before declaring a mistrial. The judge may, and this is the thing with judicial discretion, may versus must, can versus shall, require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. Rule 27D also permits a judge to poll the jury when a verdict is returned and before the verdict is recorded. However, a judge is not required to accept. So even if they would have come down with a partial verdict, the judge did not have to accept a partial verdict before declaring a mistrial. And is prohibited from doing so on a single indictment that contains lesser included offenses. So that's something the Commonwealth argued. That's a little bit apples and oranges on a single count indictment. Here, the jury were instructed on 3 separate indictments along with 2 lesser included offenses on count 2, but the trial court record offers no indication that a partial verdict was imminent or possible. The jury's first note simply stated they were unable to reach a unanimous verdict without reference to any specific charge. The second note reiterated that consensus was unattainable and acknowledged the implications of the jury's deadlock. Neither note suggested the jury had reached or could reach consensus on any subject of the charges. And we have cautioned against assuming a final verdict exists from general reports of deadlock. And again, take out the Karen Reed case, take out, what we know from the jury conversation post-trial, because that is very, very different. At that time, you don't want judges doing things like this in normal trials. In fact, the jury's third note implied they were deadlocked on all charges. Some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. So we read this when we discussed the arguments back and forth. And from my perspective, I could see multiple ways of reading this. I could see the way the defense read it. I could see the way the Commonwealth read it. Well, this court adopted the way the Commonwealth read it. They read it the way the Commonwealth reads it, which really only leaves one conclusion for them, and that's to deny this motion. Although the court relies on post-trial affidavits to suggest the charges referred only to counts 2 and its lesser included offenses, we assess the trial judge's decision based on what was known at the time of her decision. That's so important. And that's also why sometimes what we find out after, although it can be illuminating and we can learn from it, it's not something they take into account. As one court has observed, allowing post-trial juror accounts to affect analysis would create endless confusion and controversy. I don't disagree. In cases where a mistrial has already been declared due to a deadlock. And again, if they would have come back and been like, oh, we were guilty on this count, never would that fly. Never would that end up being the actual verdict. In short, the record before the trial judge suggested complete deadlock. The first and second notes provided no indication of a partial consensus, and the third note plainly implied the opposite. The mere theoretical availability of partial verdicts does not obligate trial judges to conduct further inquiry, does not require, does not obligate them. They don't have to, but they can. Where no party has requested a partial verdict be taken, or the jury does not indicate that it has reached one. Further still, these notes indicated that additional inquiry into the jury's deliberations risked producing a coerced verdict. And that's the next big point I want to talk about, is the coerced verdict that we want to avoid, especially for defendants. But before we even get there, the judge doesn't have to do it, number one. And number two, nobody asked, including the defense. There was nothing in any of the notes. We can look back now. We can analyze and say, oh, this or that. We think it means this. We think it means that. But in reality, nobody at the time was thinking that happened. Nobody at the time was pushing for that. And that to me is so important. If they would have pushed for it at the time, if they would have asked for it at the time, I think their argument would be much better now. But because they didn't ask for it at the time, it did create an issue with this argument. And I know people that believe Karen Reeder guilty are going to take a victory lap and thinks that's exactly what this says. This honestly has nothing to do with guilt or innocence. This is purely about procedure, and so that you all understand, you all out there understand judicial discretion and how important that is. And people that don't think judges can have an effect on a trial or a case, they're wrong. And then prosecutorial discretion and what they can do and how they're protected, and law enforcement. All of that is incredibly important. And before we get to what a coerced verdict looks like from the judge and why we want to think about this generally from all sorts of cases, let's take a quick break. I need to catch my breath. We're going to go ahead and run an ad. And if anybody owns a home, this is a free trial that can really help you out. And I did it myself, and I found some interesting stuff. So check this out and let me know if you guys end up using it. Did you guys know there's a new scam out there that the FBI is calling house stealing, where these scammers can transfer your title on your house out of your name using a one-page document they file at the county? And then they can take out loans against it, or even sell it behind your back, or sometimes try to rent it out while you still own it. And the scariest part is you might not find out about it until collection or foreclosure notices start arriving in your mailbox, leaving you with an absolute nightmare. Well, the best way to protect your equity in your home is with Home Title Lock's exclusive $1 million triple lock protection. This service offers 24/7 monitoring, urgent alerts, and if fraud should occur, their US-based restoration team will spend up to $1 million to fix the fraud and restore your title. That's why I've partnered with today's sponsor, Home Title Lock, to offer you a chance to make sure you're not already a victim. When you use promo code LYK at HomeTitleLock.com, you'll get 30 days of free protection and a free title history report to lock in your peace of mind. And be sure you check out the $1 million triple lock protection details when you get there. So that's risk-free. You get a free 30 days at HomeTitleLock.com with the promo code LYK. All right, let's continue reading, because this is one of the more important parts of the answer of the ruling. Judges must carefully avoid actions that might pressure jurors into compromising their genuine views of the evidence. And we have long recognized that deadlocked juries are particularly susceptible to coercion. And that's why, when I said at the time, it was very clear to me that the defense themselves did not want to push further. They were fine with a mistrial. They wanted the Tui Rodriguez instruction sooner. They can say whatever they want now. I'm giving my analysis real time during the trial, what I was thinking that they were thinking and what I was thinking they were doing and why. It is precisely for this reason that judges are statutorily prohibited from ordering further deliberations by a deadlocked jury that has twice reported being at an impasse after due and thorough deliberation, unless they explicitly consent or seek clarification of the law. If after due and thorough deliberation, the jury report to the judge twice that they are deadlocked, they shall not be sent out again without their own consent, unless they ask from the court some further explanation of the law. The risk of coercion is also heightened when a judge inquires about the possibility of a partial verdict following a deadlock, as we have explained. Where the jurors have twice reported themselves deadlocked and have already heard the Tui Rodriguez instruction, a judge's inquiry concerning partial verdicts cannot avoid communicating to the jury the judge's desire to salvage something from this trial. And this is the coercion part. Does this push too much? Does this push too much and too hard for a jury to at least give the judge something? And will they have some compromise verdict? And by the way, let me just tell you, because we're looking at this through the lens of the Karen Reed case and pushing for this should be not guilty verdicts. This should be not guilty verdicts. Why is it not a not guilty verdict? But most of the time, defense lawyers have pushed for all this case law, and all this precedent has been set by defense lawyers saying, we can't do this, or a jury might just say, okay, fine, we'll just convict on count 3. Let's just convict on count 3, stay hung on the others, or, whatever, split the baby verdicts, which defense attorneys usually hate and fight so hard against. That's why this is a very different argument than we're used to seeing. And why so much of this comes from defense attorneys' mouths arguing we cannot coerce and push the jury because they may think the judge wants you to convict this person. And we can't have that happen. However, the inquiry is articulated or explained. The import of the inquiry is unmistakable. Can't you at least decide a part of this case? The inquiry by its nature plays on the deadlocked jurors' natural sense of frustration, disappointment, and failure. The jurors are confronted with the request and asked to absorb its inherent complexity at the worst possible time when they are tired, anxious to be discharged, and perhaps angry at fellow jurors whom they blame for failing to reach agreement. In this case, the risks of coercion were evident. After receiving the third note, the judge was statutorily barred from ordering further deliberation without the jury's consent. Far from suggesting that the consent might be obtained, the third note made clear that further deliberation would only serve to force the jurors to compromise deeply held beliefs rooted in sincere adherence to their individual principles and moral convictions. So let's also play one more game of hypotheticals in our head. Let's assume, hypothetically speaking, that we do not have the juror comments and notes post-trial. If we don't, we're not here. We're not having these discussions. There's nothing really ambiguous about these notes. Judge Cannoni did what was within her discretion at the time. And that, to me, is what we're asking here. At the time, what they knew, that's this analysis. And I don't really think there's another way to read it. I really don't. Or else we'd never have a mistrial if we pushed and pushed and pushed and coerced a jury until they ended up reaching a verdict, or at least a partial verdict. What changed everything was the notes we got afterwards from the jurors. And we talked about what could happen, what should happen. I wish the judge would have asked them questions. I wish the Commonwealth would have asked them questions. And I wish if the Commonwealth got more information that they voted not guilty, they would have dropped those charges. To me, that's the right thing to do. But the right thing to do is very different than what the Supreme Judicial Court is going to decide in a motion like this. And I want to make sure we think about it correctly, right? This was not a, we think Karen Reed is guilty. This is not a, we think Karen Reed is innocent. This is not a, we think the defense attorneys are trying something slick. This is not a, we think Judge Cannoni's the best or we think Judge Cannoni's the worst. That's not what any of this is. Statutory prohibition on ordering further deliberation was designed to prevent jurors from being coerced into reaching a verdict in the face of views conscientiously reached and held. Asking jurors whether they would nonetheless consent to further deliberation would have implicitly pressured them to compromise those beliefs in order to salvage some part of the trial. In these circumstances, there is simply too great a risk that any resulting verdict would merely be the product of one hasty final attempt to satisfy the judge's apparent desire for some form of decision in the case. And if the judge were to inquire about the possibility of a partial verdict, by definition, any further discussion amongst the jurors regarding their response to the judge's partial verdict inquiry would itself be further deliberation in violation of the statute. So what this means is, if she would have even asked, will you guys go back and talk about this some more? Would you go back? And maybe you can agree on one of the partial verdicts. She is now asking them to continue deliberations without their consent, which would violate the statute. Now, of course, there's ways that she can ask for their consent before they go back and partially maybe decide this verdict. But I'm being honest, the way I looked at it, I did not see any of this until we heard from the jurors later as a possibility during deliberations when we were reading those notes. I remember I was on vacation. I was doing the lives. We were talking about it for an hour or two, like what's going on? Who wants a hung jury? Are they going to hang? Will they come back with a decision? Will there be a partial verdict on a lesser included? We were talking about all that. And nothing tipped us off to the fact that maybe the judge should do this. And maybe it would be good for Karen Reed. And you can almost rubber stamp that because the defendants didn't even make this argument. Indeed, if the judge had inquired about a partial verdict on her own initiative and the jury returned a verdict of guilty on any of the counts, there is no question that this defendant would be making a strenuous and potentially meritorious argument that the guilty verdict was the product of coercive intrusion into the function of the jury. This right here is all you need to know about how this court made the decision. They flipped it. If the roles were reversed, what would we do? And they're like, you know what? We might even throw out a guilty verdict if the judge pushed and it would have been a guilty verdict. I appreciate the fact that they did this. I agree with them. And I think they should have overturned a verdict if the judge would have pushed too hard and they would have come back with a guilty verdict. Thus, given the entire course of jury deliberations and the emphatic language on the third note that the jurors were deadlocked on the charges and that further deliberation would be coercive, the judge acted within her discretion in declaring a mistrial without inquiring sua sponte about a partial verdict. Judge was not required to ask if they would consent to further deliberations before declaring a mistrial because the jury had already received Tui Rodriguez's instruction and the final note unequivocally stated they were deadlocked. So again, this says the judge was not required. And anytime we discuss what a judge does or does not do, I see Kurt's in the chat. What's up, Kurt? Anytime we do discuss what a judge does or does not do, can and cannot do, we have to look for the language to determine were the judge's hands tied or did they have discretion? And when they say the judge was not required, that means she could have but did not have to. And it's a lot harder to overturn something that is within the judge's discretion. For much of the same reason, the trial judge's decision not to poll the jury sua sponte to confirm the deadlock before declaring a mistrial did not constitute an abuse of discretion. And nobody said it did at the time, by the way. That's important. Don't let people trick you, myself included, because I say this all the time. My opinion will change when I get more information. When I get more facts, my opinion will change. Don't let that change what I said or what anybody said at the time this was happening in real time with the information we had. Because once we get new information, the law has ways to deal with that. The law has ways to deal with that. And it's not, I love when the thumbs up comes up. The law has ways to deal with that, and it's not to look back and pretend we knew everything we knew at the time back then. So that's important. Polling jurors about whether further instructions or deliberation would be likely to resolve a deadlock is discouraged due to the risk of coercion inherent in questioning jurors, particularly in the individual colloquies. By the way, I would be remiss if I didn't pause every time and say it's discouraged right here to push when they're deadlocked because most of the time criminal defense attorneys object and argue against it. K9 Lover said, I'm sorry, Peter, but this judgment was wrong. Tell me why it was wrong. Legally tell me why it was wrong. I want to hear why it was wrong. Not why you disagree with the outcome or that you think the charges should have been dismissed. Fine. But tell me why you think this was wrong. Because criminal defense attorneys are the ones that usually object, and prosecutors are the ones that usually want to push for more deliberations, which guess what? Is exactly what happened in this trial. The defense attorneys were ready for the mistrial. The prosecutors wanted to push. And honestly, that's why this case law is the way that it is. A trial judge is not required. And I'll tell you myself, I would do the same thing. I don't care how confident I was or how much I think I won. When they're deadlocked for hours and hours and hours and hours, I start to get a little nervous because they convict her. Now she's going to prison, right? Mistrial, we can spin as a win. Maybe they'll drop the charges. Maybe they'll negotiate some, plea deal down to a lesser included misdemeanor. There's options after a mistrial. After a conviction, it's much harder. And you're seeing how hard it is when you appeal things up. A trial judge is not required to consider every conceivable alternative before declaring a mistrial. And we discern no abuse of discretion in the judge not pursuing alternatives suggested after the fact by defense counsel based on information obtained after the mistrial was declared. If an alternative which was neither suggested by counsel nor considered by the judge is later developed, we will not fault the judge so long as an honest inquiry into alternatives is made. And this is why a trial lawyer's job is so difficult. And I didn't blame them. It's not malpractice that they didn't bring some of this up during the trial, but the fact that they didn't bring it up matters. Jennifer said morally wrong and legally wrong could be two different things. Sure. The interest of justice and what the laws say, or at least our definition of the interest of justice, I agree with you sometimes. That can happen. But this is how the higher courts look at things. If you didn't suggest it at the time, defense counsel, and nobody knew about it, we can't fault the judge for not figuring it out at the time. Because you're sitting there as the defense lawyers and making every argument and thinking about what can benefit my client. The Commonwealth sitting over there thinking, what can benefit the Commonwealth? And if neither one of you guys came up with reasonable alternatives, if you would have come up with it and asked and the judge said no, maybe it would be different analysis. And so this is a great question. And again, I'm not hating on anybody for these. I appreciate these questions. Vanna, why isn't the focus on why the judge didn't clarify or ask if all counts? The defense, this is exactly what the part I highlighted here, which says, if an alternative which was neither suggested by counsel nor considered by the judge is later developed, we will not fault the judge so long as an honest inquiry into alternatives is made. The defense did not ask her to clarify, is it each individual count? The defense did not ask her to poll the jury on each individual count. And that's important. If they would have asked her, maybe the analysis would be a little bit different. And again, we've got thousands of people looking into this case, asking the question, seeing how this was fair or not fair. A defense attorney or a team sits in there in the moment, all the pressure on them, all the just adrenaline just coming down from the trial, trying to deal with these things. It is a difficult job. And kudos to the ones that do it great, which these defense attorneys did. We have never required a trial court before declaring a mistrial because of a hung jury to consider any particular means of breaking the impasse, let alone to consider giving the jury new options for a verdict. You want to know why? Defense attorneys don't want them to. That's why. The defendant further contends separately from the availability of alternatives that it was an abuse of discretion to declare a mistrial without first notifying defense counsel of the content of the third note and allowing an opportunity to be heard. I agree that's a problem. Let's see what the court says about it. First, it is worth noting that the trial judge discredited defense counsel's claim that he lacked such an opportunity. The appellate courts defer to the credibility determinations of a trial judge. P.S. Let's highlight that. That's how important this is. They just kind of assume trial judges are credible, right? We can look back to some cases like the YSL case. Maybe that assumption's not the best. Hey, Jenna, thanks for stopping in and saying hi. The judge explained that she had previously sought defense counsel's views after receiving each of the first two jury notes when counsel had argued that the jury was at an impasse. The only alternative proposed by defense counsel during these exchanges was an issuance of the Tui Rodriguez charge, which the judge granted. When the third note prompted the mistrial, defense counsel neither objected nor expressed any dissatisfaction, even when the parties remained in the courtroom to schedule a subsequent status conference. So it's going to be hard for me to argue with that because that's exactly what I said at the time. And that's exactly what I said afterwards when we were hearing these arguments, is that's not really the feeling in the courtroom when this was all happening. In any event, there is no indication that inviting defense counsel to participate in a third round of consultation would have produced any fruitful alternatives. She still should have. She still should have. It was wrong. I wish she would have. But with the evidence we have, there's nothing really to say anything would have been different. Sure, that's why you do it. We don't want to minority report this. We don't want to predict what's going to happen in the future because we will be wrong. So you have to do it. She didn't. That's a mistake. But if you look at the analysis done, I understand. Amy's Positive Pathway says, as much as I dislike it, I understand the legal basis. Amy, kudos. Because we're not always going to like how something turns out. We're not always going to like maybe the right decision being made. It's best if we just try to understand it and deal with it and make decisions in our lives, right? To make things better, make sure we can do justice in our lives, right? We can promote justice. We can make just decisions, maybe not to the level that it feels like in this case, but look at it, understand the difficult decisions and positions people are put in. We're put in those positions in our lives, at work, with our families, with our friends, whatever it may be. That's important. Kurt said he's never wrong. Speak for myself. I will speak for myself. I am wrong sometimes. I like for the method of how I got there to be right, even if the end result is wrong. So that's what I try hard to do. But I realize I will be wrong. As discussed, the receipt of the third note barred the judge from requiring further deliberation without the jury's consent because they had already engaged in due and thorough deliberations and twice reported being deadlocked. Guess what? This does not mean the judge doesn't have to tell the defense. I get what the court's trying to do here, but this does not mean the judge does not have to ask the defense or show the defense that third note. They absolutely should have. Furthermore, nothing suggested that defense counsel would have requested an inquiry into the possibility of a partial verdict based on the content of the jury note. I agree with that. Having displayed no enthusiasm for the rendering of a partial verdict while the jury was still impaneled and a guilty verdict still possible, the defense may not seek to overturn the court's order of a mistrial after discharge of the jury. This is the hindsight is 2020 rule. When you find out you would have won if something would have been different, you can't go back and try to change the rules. That's how it is. While the more prudent course might have been to read the third note to counsel and provide yet another opportunity to be heard before declaring a mistrial, the trial judge did not abuse her discretion in failing to do so. In sum, we conclude that the trial judge acted within her discretion in declaring a mistrial without first inquiring about a partial verdict or offering defense counsel an additional opportunity to be heard. Considering the length of the jury deliberations, the judge's prior efforts to encourage consensus, and the increasingly emphatic tone of the jury notes indicated deadlock, it was clear the jury had reached an impasse. It is difficult to imagine that a competent defense attorney, upon learning that some members of the jury firmly believed the evidence proved the elements of the charges beyond a reasonable doubt, would request that the jury be instructed to return verdicts on any charges where agreement had been reached. As other courts have recognized, a defendant may have a tactical reason for not requesting the trial court to question the jury about a partial verdict, and the trial judges should not be required to inquire about partial verdicts on their own initiative. So this is actually a really good point. I didn't think of it. I didn't mention it before. When they see the note that there are some jurors that absolutely believe these charges have been proved beyond a reasonable doubt, guess what? No defense attorney is going to push. Let's get these verdicts. Even if it's a partial verdict. Make it happen. Because they know, based on the jury notes, there are at least some jurors on at least some counts that think it's guilty beyond a reasonable doubt. Smitty, Canton native here. This case is the epitome of Canton County culture. Connected to the McAlberts equals Karen Reed guilty. Everyone else, free Karen Reed. You should have seen the CPD Xmas decorations. Peace on earth. Absurd. So I've talked to a lot of natives, and what's interesting is I have multiple cases at my firm right now and have nothing to do with Karen Reed from Massachusetts for people that found me and got to know me from this case. They've called like, hey, my fiance got hit by a car, trucking accident case, whatever it may be, injured at a facility. And they call from Boston, from Massachusetts, and they talk to me about these cases. And they're like, it's wild how this affected our community and how polarizing it's been. It's like the polarization of politics, it's the same in this case. It feels the same in this case. And it's wild to me that happens. But it's absolutely true. And it does happen. Cat, juror notes said charges. It did not say counts. Couldn't they have meant what they said and did mean they couldn't agree on lesser charges, not the counts? Is there a legal difference, Peter? So a lot of times those are used interchangeably. Different jurisdictions mean very similar things with charges and counts. So I'm not sure that would have been an obvious tip. And what I'll just tell you is what my brain was thinking at the time. My brain is turned on when we talk about these things. I don't look at them like my own cases, okay? I'm not digging into them like I dig into my own cases, but I dig into them a decent amount. That didn't pop into my head. That didn't pop into my mind. I wasn't thinking when I read it that there was some differentiation that needed to be made. Mo, you make understanding these rulings so much easier. Thank you for all you do. Your voice is so welcoming after being at the hospital for a week. Mo, I'm so sorry to hear that you were in the hospital. I feel like my voice is anything but welcoming. I feel like my voice adds stress because it feels like it's hard to talk sometimes. And I've had sporting events for my kids, pickleball, all sorts of things that have made me lose my voice over the last 3 or 4 days. And George, my nephew, if any of you guys follow me on Twitter, I posted about his senior night game. They have a regional game tomorrow night at home. I will be there cheering my head off. So I will probably lose my voice again tomorrow night. Plus I'm playing pickleball in the morning. So it's like voice is going to be shot from here on out. But Mo, so pumped to have you with us. And thank you for the comment. Kitagi, a pro hoc vice motion has been submitted for Mark Betterow to join Karen's legal team. I'm glad she has a lot of support. Hopefully she stops doing interviews until she is found not guilty. This coming from an attorney. Yeah, I mean, they know what they're doing and they know this case and they know the feel of the vibe there. So I trust them, but I wouldn't necessarily do it if she was my client personally. I was going to say something else. Oh, the Betterow thing. That's really interesting. That is really interesting. I wonder if he's just going to bill hours to add to the bill but not get paid, or how all that's going to work. Lots of Georges in the Treos family. My son's name is George. We call him Maverick, but his first name's actually George, after my dad as well. So yes, I got uncle's name George, dad named George, son named George, nephew's named George. My middle name is George, one of my middle names. Okay. Furthermore, nothing suggested that the deadlock was limited to a specific charge. On the contrary, the notes contained no inkling of agreement. And the third note implied the jury were deadlocked on all charges. Under these circumstances, given the content of the notes and the fact that the defense counsel did not request further inquiry, engaging in one sua sponte risked coercing a verdict. So again, a lot of people didn't like it at the time, and I wasn't saying it was legal malpractice, but this is a big point. The fact that defense counsel did not request further inquiry at the time is huge. Thus, the judge appropriately exercised her discretion in declaring a mistrial based on manifest necessity. The judge did not abuse discretion in declaring a mistrial after 4 days of deliberation where the jury had reported impasse and received Tui Rodriguez's charge, but remained unable to reach a verdict and stated in response to judicial inquiry that additional deliberation would not result in verdict. No abuse of discretion in declaring a mistrial without first asking whether the jury would consent to deliberate further, where the jury had already been given the Tui Rodriguez instruction and final jury note unequivocally stated that the jury were unable to come to a unanimous decision. Because we conclude that the trial judge acted within her discretion in determining that declaring a mistrial was manifestly necessary, we do not need to address the defendant's alternative argument that defense counsel did not consent to the mistrial. Similarly, we do not address the defendant's ancillary argument raised here for the first time that the court should have conducted a colloquy with the defendant before finding such consent. All they're saying there is, because they found the trial court did the right thing in manifest necessity, they don't even need to get to step 2. All right, the defendant's claims of acquittal. So this is part 2. This is one of the big parts dealing with what we found out afterwards. Kelly said, I've called your office for a consultation. Well, good, Kelly. I'm glad. And hopefully we were able to help you. We can't do everything, right? We handle specifically wrongful death cases, personal injury cases, trucking accident cases, things like that. And if it's something else, we try to connect you. We know a lot of lawyers, but we don't know every lawyer everywhere. So we do our best. No guarantees, but I always try to at least help people as much as I can. Defendant's claim of acquittal. The defendant separately argues that she cannot be retried on count 1 or count 3, regardless of whether the mistrial declaration was proper. She contends that post-trial information from 5 deliberating jurors indicating the jury were deadlocked only on count 2 and had unanimously found her not guilty on counts 1 and 3, effectively amounts to an acquittal of those counts. Alternatively, she asserts that the trial judge abused her discretion in denying a post-trial inquiry to verify these accounts of juror deliberations. We examine each contention below. So this one is, first off, she should be not guilty, but if she's not guilty, at least the judge should question the jurors. Claim of acquittal based on juror disclosures. The double jeopardy clause of the United States Constitution prohibits retrial on the same offense after acquittal. To determine whether an acquittal has occurred, we look to whether, given the operation of state law, the jury acted on their view that the prosecution had failed to prove its case. Because this presents a legal question, our review of the trial judge's decision is de novo. Relevant here, the fundamental requirements for a jury's issuance of a verdict in a criminal case are set forth in this rule. Pursuant to that rule, a valid jury verdict must be unanimous and returned by the jury to the judge in open court. Our case law confirms that a criminal verdict is effective only when affirmed by jurors in open court. The only verdict which can be received and regarded as a complete and valid verdict of a jury upon which a judgment can be rendered is an open and public verdict, given in and assented to in open court as the unanimous act of the jury and affirmed and entered on record in the presence and under sanction of the court. So I love to see all these cases cited, by the way, in orders. We've seen some cases where lawyers just don't cite case at all. It's not a good way to win, number one. Number two, to think that this was ever going to be adopted as the verdict was unrealistic. What happened afterwards, again, from my opinion, it really is a situation where that was never going to be the case. In the interest of justice, it really came down to the prosecutor's office doing the right thing, finding, if we talk to the jurors, if this really was not guilty, to drop the charges. That was really the way to get to the just result, in my opinion. This really was never it. So Jen said, Peter, read the juror responses to this decision that was given to Christina Rex. It's very telling how discouraged they were the entire process. That's interesting to me. But again, as horrible as that is, I can't blame the Supreme Judicial Court for their decision based on what they knew at the time and based on the information the jurors told the court and the judges. In other words, the distinction between informal agreement on a verdict and the actual return, receipt, and recording of the verdict in open court is central. Only the latter constitutes a final verdict on which the jury on a criminal charge. We have consistently reaffirmed this longstanding distinction throughout our jurisprudence. In this case, it is undisputed that the jury did not announce a final verdict on any charge. Although the defendant has submitted affidavits claiming the jurors reached an agreement on counts 1 and 3 during deliberations, the only statements made in open court reflected the jury's inability to reach a unanimous verdict. As discussed, the jury submitted 3 separate notes to the judge indicating deadlock, culminating in a final note indicating that some members of the jury firmly believed that the evidence surpassed the burden of proof establishing the elements of the charges, while others did not. Far from an affirmation in open court of unanimous agreement on counts 1 and 3, these notes clearly reflected a lack of consensus on the charges. Even if the jury's deadlock pertained specifically to count 2, their notes made no such distinction, nor did they indicate any verdict would be returned to the judge in open court, as required by the rule. In the absence of a verdict returned, received, and recorded in open court, we cannot conclude that the jury acted on their view that the prosecution had failed to prove its case. However fully it may be made to appear that the jury arrived among themselves at the decision that the defendant was not guilty, there is no claim that they agreed to report or return, or that they agreed to report any agreement whatever, except that they could not agree. And again, when we think about this on the flip side, if the Commonwealth was pushing for a guilty verdict under these circumstances, I would be pounding the table. No way. That's unjust. We can't do that. Julie, even at the time, the defense not speaking up was an issue for me. They had no problem speaking up during the trial. I agree. They're great defense attorneys. They're confident. They didn't care to argue with the judge, to butt in, to fight zealously for their client, which is what they should do. Michelle, I get/agree with the court's ruling on this issue, but isn't it wild that the jurors who wanted to inquire on this issue were allegedly told no by the foreman? Again, now we're getting into things that I just don't know if they're true. If that is true, that's an issue. Bring it up, see if there's something we can do about it. But I don't know for a fact that that's true. We're wading into waters where I have to be careful what I say about what we know and what we don't know. The defendant nonetheless argues that any lack of formality in the jurors' intended dispositions of counts 1 and 3 should not prevent those dispositions from taking legal effect. I would disagree with that. However, the requirement that a verdict be returned and affirmed in open court is far from a mere formality. Rather, these principles recognize that, as a practical matter, jurors may agree in the course of deliberations to a tentative compromise on the facts of a case or on the disposition of related charges as they attempt to reach unanimous agreement. Since a jury should not be precluded from reconsidering previous vote on any issue, a juvenile, tentative or conditioned agreements reached amid deliberations cannot have the force of a final verdict. A jury should not be precluded from reconsidering a previous vote on any issue, and the weight of the final adjudication should not be given to any jury action that is not returned in a final verdict. Requiring a jury to publicly affirm their verdict in open court thus serves a vital purpose. It ensures that the verdict agreed upon in private truly reflects the unanimous and deliberate judgment of each juror under public scrutiny rather than a tentative compromise. I agree with that as well. That's why in some of the affidavits, the jurors saying we would all agree to that absolutely in public right now would be so important to have this conversation in open court. Maintaining this distinction between private deliberations and public verdicts is essential to preserving both the confidentiality of jury discussions and the integrity of the judicial system, which is also why we're even allowed to poll jurors. Did you get coerced? Publicly, are you agreeing with this with what you agreed in private? It's kind of the point. Thus, because the jury did not publicly affirm that the defendant was not guilty of the charges, there was no acquittal barring retrial under the double jeopardy clause. Signed verdict slips reflecting votes of not guilty found in the deliberation room after a mistrial had been declared due to a deadlock did not constitute acquittals. We talked about that case. Information indicating that the jury were deadlocked 11-1 for conviction of murder, but only in the second degree, had purportedly agreed that the defendant was not guilty of murder in the first degree, did not bar a retrial because there was no open and public verdict of not guilty. Request for post-trial juror inquiry. So here's the juror interview request that I wish they would have done. I think it would have been helpful. I think we could have learned. I care about justice. I want the just result. If they did this, I think it would have helped. But was Judge Cannoni legally required to? Was she legally required to? Finally, we consider the denial of the defendant's request for a post-trial juror inquiry. Generally, a judge is not obligated to investigate jury deliberations unless there is evidence that jurors were exposed to extraneous information or demonstrated racial or ethnic bias. Even in cases of alleged bias, however, judicial inquiry cannot delve into juror subjective reasoning or deliberative content. Because the trial judge is afforded broad discretion in assessing whether a post-trial juror inquiry is appropriate, we review that determination only for an abuse of discretion. Here, the defendant concedes that the affidavits do not indicate exposure to extraneous matters or juror bias that would suggest her right to an impartial jury was compromised. So there are two ways to look at this. They didn't allege that because they want to say, no, there's nothing outside affecting this. They did it right and they came to a not guilty verdict. But the best way to get a verdict overturned or to get something to happen to show there was some kind of misconduct in the jury room is to talk about the outside influences or if there was some kind of bias in there. Instead, she argues that the affidavit suggests an unannounced verdict, warranting further inquiry. Yet, as discussed, a verdict as a matter of law requires a public announcement in open court. No verdict exists if none was announced, or even intended to be announced by the jury before they were discharged. Once the jury has been discharged, they have no further power to deliberate or to agree to a verdict. And this was the other question I had. What did the jurors talk about? What did they find out? What did they look up? What do they know now that they've been outside the jury room? Because none of that can really come into play. Allowing inquiry into a private agreement reached in the secrecy of the deliberations room would also contravene our prohibition on probing the content of juror deliberation. So I disagree. I think there are ways you can do it without digging into that. Just asking what the vote was, yes or no. But again, it would have to be what the vote was at the time, not now that you know X, Y, or Z. Mandy said Jackson asked to adjust the verdict sheet, but denied. Yes, that's very different. And he didn't ask for anything at the time. There was an impasse or a jury deadlock. And I see Kurt saying that was denied. I believe they asked for even further change or different changes. It wasn't exactly what they wanted. It was changed. Absolutely. There were still some confusing parts, but regardless, what they did at the time of the first juror deadlock, the second juror deadlock, the Tui Rodriguez instruction, nothing indicated they wanted a partial verdict or a polling of the jury at the time. That's my feeling of it. I was going to hold this, but since we got one comment from Kurt, let's see what his opinion is on this decision. I agree with this decision on the law 100%. I also think the case should have been directed verdict, not guilty, based on sufficiency, and I am amazed 9 jurors somehow thought guilty as to anything. Well, Kurt, as you know, It's hard to change a juror's mind. They walk in, they see cops, they see prosecutors, they see somebody sitting over there in the defendant chair, and they immediately think guilty, and they have to be convinced that person is not guilty. It's a sad reality, but so many times that's how it starts. And so as bad as cases may be, still, the vast majority end up with guilty verdicts. Not always, but if you ask most people and most jurors that are not maybe true crime fans or really dug into the system, I think they feel like usually people that get arrested and prosecuted are guilty. Why would they be here? Why would the cops think they did it? Cops are good. Prosecutors are good. They're government lawyers. Seems like the judge feels like they're guilty too sometimes, they think, right? It's tough. Allowing inquiry into a private agreement reached in the secrecy of the deliberation room would also contravene our prohibition on probing the content of juror. I always want to say content of juror deliberations. Maintaining the secrecy of those deliberations is a bedrock of our judicial system. It's funny, right? It's a bedrock of our judicial system. Why? It's like we want to be cool with it if they get it wrong, or there's guilty for the wrong reason, or if it's not guilty for the wrong reason. All of that is kind of like, I don't know. It's interesting to me. It not only prevents jury tampering, but also upholds the finality of jury verdicts and fosters confidence in the judicial process. Probing secret deliberations to determine whether the jurors may have privately agreed on a verdict they never returned would undermine these fundamental principles. Juror testimony as to part which he or she took in the discussions and vote of the jury is not permissible because it relates to the private deliberations of the jury. Even though post-discharge inquiry asked jurors to disavow the non-existence of a verdict rather than to impeach a verdict already in existence, it still constituted an improper inquiry as to jurors' mental processes. Were it otherwise, jurors would be harassed and beset by the defeated party in an effort to secure from them evidence of facts that might be used to set aside a final verdict. I get that, but there's already things in place to protect them from being harassed, right? They can already say, I don't want to talk to you, and if you talk to me, I'm calling the court. So I don't necessarily know that should be a big concern. It already happens. Nor is the defendant merely seeking juror testimony as to a mistake entered on a final verdict form. Permitting juror testimony about mistakes made in entering the final verdict on the verdict form. Here, there is no suggestion that the jury's failure to return a verdict was the result of a clerical error. The post-trial accounts do not dispute that the jurors had reached an impasse, as they reported, and had decided not to return a verdict slip on any charge. No juror expressed surprise or disagreement in court when the judge declared a mistrial based on the jury's report that the court could not reach a unanimous verdict on the charges. That's a good point, and that's exactly what happened here. Nobody was like, hold on a second. We were not guilty on count 1. Hold on a second. We were not guilty on count 3. Now, clearly, they didn't know they could do that, right? Juror inquiry permissible where jurors audibly answered no during the polling of a juror, of course. Additionally, the limited exception for juror testimony concerning the mistaken verdicts only results in alteration of a verdict where there has been no opportunity for outside influence. No opportunity for outside influence, not proof of outside influence, right? Here, all the defendant's affidavits concern jurors' accounts to others after leaving the control of the court. When the jury leaves the sterility of the court's control, contamination is presumed. And that's another one of maybe the surprising parts of this order. Contamination after they leave the court's control is presumed. So they're talking to defense lawyers, they're giving statements, they're maybe talking to media. It is presumed, which I always find very interesting. A post-trial inquiry of these jurors would similarly occur well after they become susceptible to outside influences and would not provide a recognized basis for altering the result of the first trial. The court could not alter the verdict of acquittal upon learning that the jury had intended to convict the defendant on a lesser offense, where the jury had ample opportunity to clarify or express disagreement with the original verdict when it was announced in open court the prior day. Thus, the trial court did not err or abuse her discretion in denying the defendant's request for such an inquiry where it would not change the outcome of the defendant's first trial. The jury chose to report a deadlock, not a verdict, and no basis exists for further investigation into private discussions or subjective beliefs they declined to announce publicly in open court. So this is something I would kind of disagree with this court, that no basis exists for further investigation into the discussions. I think there is a basis that exists. I just think the court made the determination when weighing the sides that that was not the correct move in this case, because they don't want to go into the deliberations of the jury, because they don't want to open the floodgates of people harassing jurors afterwards. They weighed the interests and they made a decision, which is fine. That's what judges do. But to say there's no basis, I would disagree with. Conclusion. For the reasons stated above, the trial judge correctly denied the defendant's motion to dismiss and request for a post-trial juror inquiry. The case is remanded to the county court for entry of a judgment denying the defendant's petition for relief. So ordered. No dismissal. No win for Karen Reed. No counts 1 and 2 gone. We are going to trial looking like April 1st on all 3 counts. How can SJC rely on jury not giving indication of a partial verdict in open court when the instructions explicitly told the jury not to? I will just tell you, I understand, but there have been cases where jurors still speak up. Even after that, even after that instruction, even after a verdict is read sometimes. Amy's positive pathways. Why does the grand jury indictment for murder 2 say that she did assault and beat John O'Keefe? I don't understand the wording. Is that normal verbiage? I'm not sure if it was you that asked this yesterday or somebody else. I'd have to go back and read that specifically and try to get this answer because I don't just know it off the top of my head based on the context you're giving me. So I do apologize. Somebody else asked this yesterday as well. Zeke, why do courts typically rely on precedent and shy away from setting precedent? Kind of cowardly. So generally, we want people to know what they're getting and to know what's coming. And one way that happens is with precedent. We as lawyers can look back and advise our clients and say, this is what is likely to happen. Sometimes they do overturn precedent. Sometimes they do set precedent when it's absolutely necessary, but only then. You don't want to live in a society where the laws are changing all the time. Then you don't know. You don't know. You're hanging in the balance at all times. You could be not guilty, but guess what? It might not, because precedent might be changed and that might be turned into guilty because of X, Y, or Z. You don't want to live in that world. You don't want to live in the world of ever-changing laws. You want to know what to expect. You want to be able to live your life as a law-abiding citizen, knowing what's legal and what's not legal. You want to go through a court case knowing what's likely to happen and not likely to happen. That's how lawyers give advice. It's all based on precedent. And it's a good thing. But there does come time where we need to set precedent. We need to change bad precedent. And it does happen. It's not like it never happens, right? It absolutely does happen. Ron Gotti, the judge picked the 4-person before the lottery to see who would actually deliberate. The language in the notes was too professional. I don't remember the defense objecting to that 4-person. They could have. I'm not saying it would have changed, but maybe next time they'll object to it and they'll ask for a random picking of a 4-person. Now, certain jurisdictions do it certain ways. In every trial I've had, the jury picks the 4-person. Usually we can figure out who it is based on our voir dire and the backgrounds we get on the jurors. But very interesting to me. So we got it done in an hour. I did not expect that to happen. I appreciate you guys joining me for this lunchtime live. I want to jump on it as soon as I could. Schedule's a little weird today, but make sure you guys hit that like button. Make sure you send this to anybody that's asking questions on Instagram, Twitter, that wants a breakdown of this. I've already had a bunch of questions come in, so I appreciate you guys so much. And make sure you're subscribed, because we're not going to stop with the Karen Reed content. Did the next part of the interview come out? If it did, send it to me. I'll do a video on that at some point, maybe tonight. But I appreciate you guys as always. But that's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.